Judge Beverly Cannoni denies the motion to dismiss in the Karen Reed trial, and we're going to break down what I believe is the reason and how she premeditated this to set it up in a way that makes it difficult for the appeals process, yet could also work in their favor because of the division in the Supreme Judicial Court and the lower appellate courts on what is to be decided on this issue, because it's very specific. So let's go down memory lane and watch day 32, where Jackson and the judge are fighting over verdict slips, and it doesn't go very well at first.
Why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
You said before you retired and you needed to think about it was you agree that there needs to be not guilty options for subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I ask you a question. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Thanks.
It's appropriate.
Now we're going to go to the appellate side of the law and look and see what happened in the past.
Let's look at the Supreme Judicial Court of Massachusetts appeal decision on the case of Commonwealth versus Roth. This case involved conflicting testimony and expert opinions regarding the accident and the defendant's intoxication while on scene and at the hospital.
Sounds familiar, doesn't it?
Jeffrey Roth was accused of vehicular homicide and operating under the influence. The jury twice reported being deadlocked, and the judge took partial verdicts on lesser included offenses within the indictment. The Commonwealth argued that the judge erred in taking these partial verdicts, but the court agreed only in part. While the partial verdicts were deemed improper, the not guilty verdicts would stand due to double jeopardy principles. The defendant could only be retried on the remaining lesser included offenses where the jury failed to reach a verdict.
And this is why I'm using Commonwealth versus Roth, because it's so similar to Karen Reed's situation. And the end result of that case was that they allowed the acquittals of those 2 charges, while also allowing the reprosecution of the one charge that the jury was deadlocked on.
Make my argument, if you don't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually have.
Have you had no lesser included?
No, I've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option.
Okay. I disagree with you. All right. Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise for the court, please.
It seems to me like she did not want to jeopardize having to poll the jury in any way because of the ruling in the Roth case.
The prosecutor protested that the instruction was still confusing and that the jurors had looked confused. She pointed out that the format of the verdict slip, which had not been designed to take any such partial verdicts, added to that confusion. 6. The judge explained that if the jury returned with the verdict slip blank, he would interpret that blank as unanimous vote of not guilty for the offenses charged, and that he would then inquire of the jury to confirm that that was their vote.
So the similarities are, in the Karen Reed case with this, is that the verdict slips were screwy. The judges both corrected the verdict slips, however, for different reasons. And Bev made sure to note that the verdict slips were proper originally, because that's how it had been done. And that's what this appeal decision confirmed. But I feel like there was another reason why she did this.
The jury's been waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that? I do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want, but that's my finding.
Thank you, Your Honor.
So this judge basically put a new spin on the same issue with different details, using manifest necessity as an excuse, which the decision of the appeal is based on. Take a listen.
In assessing the merits of adopting some procedure by which deadlocked juries could be asked to render partial verdicts on lesser included offenses, we first note that, consistent with the prohibition on double jeopardy, the adoption of any such procedure would effectively require judges to inquire as to partial verdicts in all cases of deadlock. In other words, if a judge may request such a partial verdict but fails to do so, there is no manifest necessity for retrial on the offenses charged. Jurisdictions that permit such partial verdicts to be taken ultimately conclude that failure to do so bars retrial on anything other than the lowest of the lesser included offense contained within the complaint or indictment.
And in my opinion, that is exactly why she declared a mistrial so quickly, because she did not want any inquiry on partial verdicts, and why they wanted to shut down any jurors from speaking out on the fact that they did decide unanimously that counts 1 and 3 should have been acquitted.